Good afternoon, everyone. My name is Jennifer Wood, and on behalf of the court and the advisory council, I want to welcome you to this series. I'm so excited. There have been many planning meetings that went into starting today in this series. And what once seemed to be kind of a complex and overwhelming undertaking is now actually a concrete thing that is happening. And that's really wonderful. I chair the Access to Justice Committee of the Court's Advisory Council. And in that capacity, we've partnered with the court's pro se clerk's office to organize and plan this exciting series. And Barbara Hurst over on the right, the head of the newly established pro se clerk's office, is actually the power behind this event happening. So very excited to be doing this. I've been practicing law in Rhode Island for 40 years this year, which is super fun. And I have never had access to the course that you are about to participate in. So I'm as excited as anyone in this room to participate in these next 6 sessions because this is a historic moment. This course has never been offered in Rhode Island before in this way. So excitement and bravo you for figuring out you should sign up. As you know, no doubt, the course will run every other week on Tuesdays from 3:30 to 5 until the final session on April 8th. Each session will yield 2 CLE credits, and the last session yields 2 of the all-important ethics CLE credits. We're asking that you fill out and leave the form that you were given when you walked in. Were people given a form?
Yeah.
Okay, great.
Where should we leave them?
At the desk where you checked in.
Thank you.
The purpose of this series, as we conceptualized it, was to make civil rights litigation feel more accessible to attorneys practicing in Rhode Island. Regardless of your current role, and in my experience, practicing law in the 21st century is an experience that is lived in chapters. So from whatever perch you may be practicing today, it is likely you'll be practicing in some other capacity at some time in the future. So regardless of where you currently find yourself in your practice, there is no question in my mind, but that you would find the information that's going to be shared in this course to be valuable. And our goal was to demystify and deconstruct a lot of the thinking that goes into Section 1983 litigation. And that's why you'll see as we march through the 6 sessions that that's taken one step at a time. We also wanted to use this course to make practicing attorneys more aware of the court's pro bono panel, which provides volunteer lawyers in civil rights litigations to persons who cannot afford to retain counsel. And if a case passes through the mandatory court screening process at the pro se clerk's office, then it may become eligible for appointment of volunteer counsel. And we're hoping that everyone who participates in this course will, in their own volunteer capacity, enroll in the panel so that they might, in the future, assist an otherwise pro se litigant. We'll talk more about the pro bono panel and how it works in the final session, but you can also begin to look at some of the information on the court's website. An audio recording of all 6 sessions will be available. So I was cautioned to mind my P's and Q's when I spoke today, because we are being recorded, as you heard at the outset. And that's also because we recognize that while many of you no doubt wish to participate in all the sessions, if you need to miss a session, do not despair, because you can fill in that gap in your knowledge and still have access to all 6 of the components of the course. At this point, unless there are questions, it's really my privilege to introduce our first 2 presenters in the series. And they're very appropriate first presenters because when people think about doing Section 1983 litigation in Rhode Island, if you've ever done that work at all, you know about these two practitioners. So Mark DeSisto and Lynette Labinger are typically associated on different sides of the V, although that is not a universal truth. And well, maybe for Lynette. But we really actually, you're seeing here today, part of the design of the course itself, because in each of the 6 segments, we've tried to ask practitioners with experience doing the thing that is being discussed on that day. And in each instance, from different perspectives representing either plaintiffs or defendants. And so today, we have 2 of the most respected and experienced practitioners to launch the series and provide you with an overview to Section 1983 litigation. If I warned Lynette that I was not going to do the usual really stultifying reading of the CV at the front end as an introduction. And she said, tell them to look us up. So without further ado, Lynette, I think you're going first.
Yes. Okay. So I am PowerPoint challenged. We'll go right. Did that work? Did not work. I was told that if I hit the space bar, it would go to the next screen. And we're all ready.
Let's see.
Challenge.
Is our tech person not in the room?
Our IT person. Said that this would do it. It didn't work? No, I keep pressing the space bar.
Right, this is a good learning moment. What do you do at trial when this happens?
Yep.
I usually tell a joke, but
There.
Yeah.
So.
I drive for you.
Oh, okay, good enough. All right. So as has been said, this is our first pass at this, so I apologize in advance. If it is either too detailed or not detailed enough. I am an attorney in private practice. I've limited my practice to cases sponsored by the ACLU of Rhode Island, and any views and statements are my own. The ACLU, if I could make a pitch, is always looking for cooperating counsel to work on pretty often Section 1983 cases. This is all of Section 1983. That's the whole statute. And it's been amended over time, but it basically dates back to 1871. It was designed to be part of the package to enforce the 14th Amendment. And make sure that the protections that were adopted by Congress and ratified by the states, 13th, 14th, 15th Amendments actually had effect. That has been a very uneven process over the, I guess we'll call it centuries, but that's where we are now. What I want to emphasize, and I can tell you right now, that we will not cover everything. And I know that in the next sessions, there will be a lot more drilling down in the specific areas that you're more likely to encounter if you are dealing with pro se litigants. But what I want to emphasize is that this language does not actually create any rights other than the right to get into federal court if you have a claim that this supports. This is just basically an enabling statute that says if you meet these standards and you have a claim, you can bring it against a governmental actor under Section 1983. So it doesn't create any rights other than basically providing this platform. But we're going to parse it out and talk about some of the elements, because notwithstanding that it seems very simplistic, I can't tell you in preparing for this how many volumes I looked at, and they're just the tip of the iceberg, that have been written on various aspects of 1983 and the underlying claims. So let's now go to the next slide. Maybe. I'll try it again. Nope. Oh, there we go. Okay. So can we get rid of, we're apparently cut off at the top. We're being defeated by technology every which way.
Oh, that was not a good choice.
No.
Okay, you need some help from someone who actually knows what he's doing. Goal is to bring back the slide deck and move the top bar.
And we're on slide 3, and to have it without extraneous stuff. All that.
You.
And that's not the right slide. So not the space bar, the cursor. Okay.
Okay.
All right, we've made it to the slide. So every person who under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia. We're just going to stop there because that's a lot. Basically, this is the part of Section 1983 that tells you that you can hold accountable a person who acts under color of state law and engages in state action. And this topic mostly focuses on whether the person is acting under color of state law. But let's start with I think the more simplistic part, which is, what does it mean by any statute, ordinance, regulation, custom, or usage? The first ones are pretty obvious. Custom or usage can be, it's been interpreted pretty broadly and can include settled practices, even if they're not formally adopted. They don't even necessarily have to be written. But they have to be more than just a one-off by an individual who happens to be cloaked with some governmental authority. The easy folks, and we're now talking about who you can name as a defendant, are public officials. They are acting within the scope of their authority, even if they misuse their authority. But if they're acting in a purely private or personal capacity, then the fact that they happen to be a government official will not make them a state actor. A governmental entity can also be a person. A quasi-governmental entity like a corporation may be a person. One big caveat is that each state is not a person within the meaning of Section 1983. And that this does not change even if the state has waived its 11th Amendment right not to be brought into federal court. But I will say more about that because everything has a qualifier. Now, every current government official wears 2 hats. Their official capacity, which is the equivalent of holding the office that the person occupies responsible, and their individual capacity, which would hold that person individually responsible. So an official who leaves office, who was sued in his official capacity, is then replaced by the next office holder. But an official who leaves office who was sued only in his individual capacity is still stuck in the suit, and any relief would have no official binding impact on the governmental entity unless you also named the office or some other entity. So each time one names the current office holder, a decision needs to be made as to whether you name them in an official or individual capacity or both. And there's a lot of decision making that goes into that. And if you're picking up a pro se complaint, it may be, and almost certainly is very inartfully drawn, names a whole bunch of people, doesn't specify what capacity they're sued in, and you're going to need to take that into account, figure out what am I trying to do. Now, if you're naming a governmental entity, do you have to follow the state rules on such things as giving advance notice of your claim to the city council, or to correctly name the municipality and not a department? We've encountered that where the Rhode Island Supreme Court has said that for liability purposes, a school committee is not a separate entity from the municipality, and someone lost their case because they named the wrong entity. That does not apply to defeat the federal claim because of something called the supremacy clause, which says that the state tail cannot wag the federal dog. So you also don't have to file a notice of a claim under the state Municipal Claims Act. But if you are adding some state claims, you need to be aware of those things too. It still makes sense to try to identify the correct entity. And to decide whether you're naming individuals or the entity itself, like a school committee or the municipality or the fire department, or you're naming the big entity and not the individual components. So I said that you can't sue a state because it's not a person under 1983. And a state department, if it's the state's alter ego, would still be the state. But quasi-governmental agencies, which have a right to sue or be sued in their own name, would not necessarily be the state if a judgment against them would not impact the state treasury. Obviously, a lot of research that you need to do, factual and legal, to make those decisions. But if you're seeking prospective injunctive relief, there's a workaround that the US Supreme Court recognized in 1908, and they continue to cite it. It's called Ex parte Young. And it basically says that even though you can't sue the state, you can sue the official charged with the enforcement of a particular challenged activity or policy for injunctive and corresponding declaratory relief without violating the state is not a person. Do you want to talk about those decisions before we move on to private person?
Yeah, let me just talk about for a minute the distinction between individual capacity and official capacity. So I see a bunch of people out there who sue frequently. You know, you're all great, but if you sue someone in their official capacity, you're suing the entity. So you're suing the town or the city, right? We know that. If you sue in your individual, you sue them in their individual capacity, you're suing them individually, and they can be within the scope of their duty. So it doesn't matter to me, you know, from a defense point of view, and all of you who do defense work or even plaintiff's work, weigh in here. I don't draw any distinction, a great distinction between individual and official capacity, except if you got someone in just in their official capacity, that could affect your damages because it really is a suit against the municipality or the town. So I get this all the time. I get solicitors. I see some of them. John, is that you back there? Yeah, see, John Radecchia, who's a great trial attorney. Had a lot of trials with John. But we get solicitors who say this all the time. You know, you sue and you sue the mayor and you sue the chief of police, you know. And the solicitor will call up and they'll say, all right, well, you know, the mayor is in his individual capacity, so you'll get him out right away. No, I'm not going to get, because the law is you can be acting within the scope of your duty and still be sued individually. And so what I try to do is head it off at the pass now. When I see a suit like that, I'll say to the solicitor, you know, it's individual, but he's gonna stay in or she's gonna stay in. You get this all the time from police officers when they're sued individually and they say, geez, I've done some research on on attorneys, and so I'm like, oh yeah, what'd you find? Geez, that Bud DeLuca, he's really great. I'm nervous, Oh, great. And he sued me in his individual capacity. Am I going to lose my house? And of course, you're not going to lose your house, because even though you're sued in your individual capacity, you're still within the scope of your duties, and you have what's called indemnification from the town. It's 45, 15, 16. I'm looking at Kathleen. Is that right? Or Bob Savage would know, or Rick. 45, 15, 16. I don't know. See, anyway, it's one of those statutes. You don't have to know it, but it gives the employee of a city or town indemnification as long as that employee is acting within the scope of his or her duty. Doesn't make a difference for you out there who are going to bring plaintiff's cases. Makes a big difference for insurance and the town itself. They have to indemnify that individual. And so whether they're sued individually or officially only makes a difference in damages, which we'll get to. How many out there that do civil rights plaintiffs work only sue in their official capacity? Right? No hands raised. You sue them in their individual capacity. And I don't bring motions to dismiss anymore to get people out in their individual capacity, because A, I'd never win. And B, I don't think anyone understands what it really is. And so just do it, and we just go at it.
No,
Okay.
I can tell you that I bring many just in their official capacity because I'm trying to avoid a jury trial, because it's strictly a matter of law, and because we're not seeking any damages, we're seeking prospective relief. And sometimes you want to name a whole bunch of people because you want them, I mean, obviously you don't name them gratuitously, but they have something to bear and you want to have them in discovery. And sometimes you want a lean case and you want to pare it down, depending on what the nature of the case is, to just enough of the people to tag the bases, the office holders, to make sure that you've got people who are obligated to enforce the challenged activity, but no more, because otherwise you're just getting interrogatories from people from all stripes, and spending a lot of time on, not everybody is as practical as Mark on motion practice. Those are things that it's not always the same decision one way or the other. Sometimes private persons or entities are also able to be named under Section 1983 as someone who's a state actor. There are a bunch of different standards. It's like they have a symbiotic relationship to the state. They're performing a public function that's basically exclusively a public body would perform it. There's a close and joint nexus. There's joint participation in the activity, or an entwinement between the private entity and the government. I think you can find examples going both ways where the facts seem to be the same and they go one way or the other. And part of that is not surprising, because there are a lot of 5-4 decisions.
Let me just point out one
Yeah.
case. If you are looking for whether or not you can hook in a private entity as a state action, look at this case. Just came out, Josh. It's Brousseau versus Little Compton, and Judge McElroy does a very good job of outlining how you go. There's 3 tests you can go through. I don't want to go through them because I don't even know what they are, but she does a great job of outlining that, right? And
I was hoping you weren't going to put me on the spot and ask me to give those 3.
well, but here's the thing, that the facts of that case are very interesting, because Tom Lyons brought a suit where Little Compton, I have Little Compton, and we convinced his client to go to the hospital. He says we forced him and we remove his gun and he said we shouldn't have done it. So that's me. But then the hospital gets involved because Josh, they hold it, don't they?
For a little bit, and that's part of the fight, but yeah.
See, this is defense attorneys. A little bit is what, 3 days?
2 days.
2 days, yeah, that's a little bit to us, but you move to get the hospital out of the constitutional violation because you say they're not state actors. And Judge McElroy agrees with you. And look at that case called Brousseau versus Little Compton, outlines it perfect.
And there's another case, Atticus versus H Press, which goes back to, I think, 1970, where the Supreme Court held the drugstore as a defendant under 1983 for coordinating with local law enforcement, a customer practice to enforce maintaining a segregated lunch counter. Most of them don't work out. Heavily regulated quasi-monopoly utility companies have been found not to act under color of state law. The public defender, even though the public defender at the state level is a government employee, has been held not to act under color of state law in providing legal representation to individual defendants. But in another context, if it's somebody in the public defender's office or a similar kind of entity who's claiming I was denied due process or subjected to race discrimination, they probably would be a state actor because that's a different function. The primary focus is whether the challenged actions are fairly attributable to the state. But let me just say one more thing, because even though you may not be able to grab the private actor acting in concert, as you would put it, with the state actor, if you've got the state actor in the case and you've articulated a 1983 claim, the state of the law now is that you can add pendant claims and pendant parties. So if everything arises out of a common nucleus of fact, the fact that you could not name the private party in federal court by themselves may not stop you if you've got your 1983 claim and they're part of that process. You could name them as a pendant party. And that also is a way when you, and I don't know when we're going to discuss Manel, because I just can't remember where it is in here, but sometimes you can't, it's a real stretch to name the municipality as a defendant under 1983, basically responsible for damages, because you need to show that that was part of a custom or practice, either adopted at the highest level or across the municipality. And sometimes it's more like a one-off. But and there's no respondeat superior under 1983. But if you've got the claim against the individual, you could add your municipality as under state law as responsible under respondeat superior. There's no barrier to that. So once you've got, and that's why I'm talking about 1983 as your platform or your foundation for building your claims. And then you need to look at what other claims might be able to tag along, either as a pendant claim against the same defendant or as a pendant party under the court supplemental jurisdiction. Are we ready to move on to the next slide?
I want to talk about color of law.
Go ahead. Yes.
So I just want to give you, because this is interactive, right? We're going to interact, right? You look just like the juries that rule against me. It's like, who is this guy and what is he saying? He's such an old man. I want to give you a couple of scenarios on color of law. So, because this is going to come up, okay? So one came up recently and Judge McConnell wrote a nice decision on it. And this was in the paper and you may have seen it. I'm going to ask you how you think you'd come out on this. So There's an off-duty police officer, I think from Pawtucket. And he's in West G and he's riding in a pickup truck and unregistered. And he's got an open can of beer. And he's not in uniform. And he is driving on the highway and he sees a Mercedes. And his testimony is it's speeding. And he follows it. And the young kids, they pull into a pizza place and something happens. I think he approaches and they don't know if he's coming at them or something. And he draws his service revolver and he shoots and he hits one of them in the arm. And he is indicted, goes to trial and is found not guilty. There's a civil suit. So I come in for Pawtucket. Mike Colucci has the officer. And Mike moves to dismiss the 1983 claim, saying my guy wasn't acting under color of law. And Judge McConnell, the case is Vincent versus I don't know what it is, Vincent versus Dolan. And Judge McConnell writes a decision where he outlines that I'm going to just read some of it. There's no single easily determinable factor to control whether a police officer was acting under color of law, but these factors are relevant. Police officer's garb, of course he wasn't wearing any. Duty status, off duty. Officer's use of a service revolver, got that one. Location of the incident, this is in West G, he's a Pawtucket officer. But he also says, you have to read the decision, that even if you're off duty, you can still be under color of law. And so if you take those facts, how many think that person was acting under color of law? And by the way, he's saying, I wasn't acting under color of law. He's not, he's not like, he's saying it. How many think you were acting under color of law?
Did he identify himself as a police officer?
No, that's before shooting or after. Neither. Anyway. I don't know. I really think, I don't want to go into the criminal trial. Mike Colucci is gonna be here talking to you about something, and he can tell you about it. I think this was jury nullification. I really think that they didn't like the young kids, but who knows? But so, having said that, how many think he's under color of law? Just a few of you. Yeah. Judge McConnell says, yeah. He says that's enough. He used his service revolver. He said he followed them because they were speeding. That's a law enforcement action. And there's enough question of fact there where that's a color of law. And if that's under color of law, most cases, you're gonna have a state actor who is under color of law. What if you have someone, I don't want to take too much time, but this is, it's cut me off a bit. What if you have someone who is committing a crime in uniform? Is that acting under color of law? So 2 examples, these are real cases. Search warrant, and someone takes, I had 2, one takes drugs and one takes money. Is that acting, that's a seizure. Is that acting under color of law? You committed a crime. How many say that's acting under color of law? Yeah, you're in uniform, you're doing it. I had the famous case of, I'm only going to give you 2 more. I had a famous case of the person who's strapped to a gurney, female, and she's mouthing off to the police officer. And he says, just one more incident. And she gives it to him. And she's strapped, and he flat out slugs her. Color of law, that's a crime. Yeah. Right. You're all on the right. Yes.
Drinking beer, having an open can of beer in the car.
Yeah, I agree with that. That's indicated. No uniform,
Yeah.
Unregistered car, but there's enough facts there, I think, that said it. Now I'm going to give you one more. This is an actual case, and then we'll move on. So a police officer is on duty, goes into a bar, Kathleen, you'll remember this. And, I won't tell you this, the town. He's in uniform, and he sees someone he knows, and the person says, pretty tough with that uniform on, aren't you? Yeah, real tough. Got the baton, you got the badge, you got the gun. Yeah, when you don't have that stuff on, and he says some bad things about it. So the officer then takes his badge off, hat off, gun off, right? Calls in, sign me out for a half. Gives the gun to the bartender. This is a true case. And says, now I don't have anything on. Let's go. They go outside, and the officer does very well in combat action. But unfortunately, what he does is he then calls up and has the guy arrested. But is that acting under color of law? I mean, he literally said, "I'm off duty" and all that. How many say acting under color of law? Judge Patine agreed with you. So that was acting under color of law. And I think we settled that case. So.
What about without that last part?
I don't know. What do you think?
Nah, if it was not the last part.
Yeah, I think had he not done that,
Just keep going.
yeah, but
The other ones that the Supreme Court has tackled with very recently, I think it was last year, is the whole social media issue. And they weren't categorical, but they focused on what is the purpose of the Facebook or other social media page if it is imbued with something related to your office and gives out information about your office or the entity that's not otherwise available, it's probably going to be considered under color of law. And if it's purely private, it won't be. So, I mean, that's like on a continuum as well as to whether it is or it is not.
So I'm going to encourage us to move forward.
Yep.
yes,
And we were.
You're good, you're good.
So the next phrase, which is going to be short, is subjects or causes to be subjected. And the question here is what type of conduct or intent is covered? Well, first of all, there's no requirement that the actor specifically intended to deprive the plaintiff of a constitutional or statutory right. They have to intend their acts. There is a requirement that an affirmative action or failure to act when an obligation has or in the absence of prospective relief will cause the challenge deprivation. And as I said before, there's no basis for liability under respondeat superior. So there's some element of intent, but not to cause specific harm, just that this was not an accidental action. And if it's a prospective, it could be mandated because they're required by their office to enforce a particular statute, which they may not like at all. But because they're the office holder, that's the person that you tag saying that they're required to enforce the statute and the statute's unconstitutional. And that is sufficient to satisfy this requirement. Anything you want to add there?
no, good.
Yeah. Okay, so I'm just going to read along. Subjects or causes to be subjected to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws. And this is huge, and we're not going to go through most of it because we will not get out of here. But as I said, it's a platform. So it's a platform. If you have an independent constitutional claim or statutory claim that relates in any way to rights, privileges, or immunities, and that is pretty broad, then you can assert it under 1983. There are some restrictions on that, but some of the different types of claims that can be asserted are violations of the First Amendment, free speech, in the public employment sector, limiting the speech of a public employee or retaliating against them for having spoken out, refusing to give a contract to a government contractor, voting rights, not hiring or firing people because of their political association, door to door or leafleting on the street, advertising, commercial or non-commercial, all those things, First Amendment. Second Amendment, if you don't know about it, you have been snoozing through the last few years. Requirements to get a permit, limitations on who can get one, are all things that are implicated and raised under the Second Amendment. The Fourth Amendment, a lot of the examples that Mark has given you, because those are a lot of the ones that he confronts in defending them. You know, when I speak of them, I mean, they have to have a Fourth Amendment component, but they're basically a constitutional variant of malicious prosecution, abuse of process, or false arrest. Excessive force in effecting an arrest. They can all rise to a violation of 1983 under the Fourth Amendment. The Fifth Amendment, an improper interrogation, denial of access to counsel under the Sixth Amendment, or a taking without just compensation under land use. Eighth Amendment, excessive punishments. The big one that you will see if you are being asked to take one of these cases, or denial of necessary medical care to people incarcerated, or deliberate indifference to their medical or other needs. The 14th Amendment is what incorporates all of these against the state. And they also have components of substantive due process, though we don't know how much of that is left, and procedural due process. If you can hook liberty, property, or a life interest as a matter of federal law, or look to your state law as grounding it, such as a legitimate expectation of continued public employment, or you were issued a professional license that's being revoked, those can be the basis for a 1983 claim. Equal protection clause, discrimination, either affecting the individual, or you're challenging a particular state or local statute or local ordinance that discriminates. It can be a protected class, or it can be not one that raises suspect classifications. The key thing on all these things, and I'm just throwing a lot of them out, is that how you prove the violation depends on the claim asserted. So you don't prove an equal protection violation or defend against it the same way you would for an Eighth Amendment violation. So that's where you look to the body of case law that deals with the particular claim that's asserted. There's also sometimes privileges and immunities clause under the 14th Amendment. And then back to the original Constitution, the Commerce Clause, and Article 1, Section 10, which is also ex post facto, but also impairment of contracts. For a lot of people, these are very esoteric. I mean, some of them are different segments of our litigation population focus on different ones because of the nature of the underlying harm, but they all can be supported by Section 1983. Do you want to talk about those before we move on to
let me just add, I won't talk about any of them, other than to say, look, here's what's going to happen. If a client comes in, whether it's from the court or someone comes in and says, I've been wrong, this is what's occurred. You've got to look and see if for a 1983 action, does it fit within any of these things? That's the fun part of, of determining. And then is there a state actor? Is the person under color of law? That's it. And I don't want to make this too simplistic, but that's the way I am. These cases are easy. You look at the incident, You say, what's the constitutional violation? Is there a constitutional violation? Is there a state actor? And then you start to strategize. We do the same thing on the defense. What do we have here? Where can we attack it? And where do we go? It's the pleading stage that you got to think about. After that, you're both defense and plaintiffs. You're in a friendly court. You got great judges, honestly. You got great clerks. Staff is great. You can meander your way through. And the trials, if you get to the trial, we try as many as we can, are fun. Have I done enough commercially? All right. I'm just saying when you look at this, look at it that way. What's the incident? Is there a constitutional violation? Do I have a state actor? Let's go.
Yeah, and a lot of times, if you're getting a pro se litigant's complaint, it will not be identifying. It will say, here's the bad things that happened to me, and you need to figure out, what categories, and it could be multiple categories this falls under, and you should look at all the potential categories. The and laws means that you can also bring 1983 claims in certain circumstances where there is no constitutional claim involved. So public benefits statutes, we brought some of those. I mean, the granddaddy, I guess not that long ago as far as I'm concerned, but it's long ago, Goldberg versus Kelly was decided on the basis of the constitutional claim. That's where the state of New York had no process to give anybody a pre-deprivation notice or opportunity to be heard before they yanked their benefits to families with dependent children. And it went up to the Supreme Court in the old days directly, because they used to have direct appeals from 3-judge court on the issue as to whether that violated due process. But if you drill down into some of these public benefit statutes, like the food stamp statute, where you're supposed to get a resolution on your application with X number of days, we've brought those cases in federal court. Not because they're a due process violation, although I'm sure we asserted it, but also directly on the literal language of the statute, which says that if it's an exigent circumstance, you only have like 10 or 15 days, and
30 without.
and you remember that because you were on the other side of that
Just
one.
so
Yes.
it was
So public benefits can be part of the and laws. But there are a number where the Supreme Court has said that if there's a comprehensive statutory scheme that has all the components of how you go about litigating that, then it is not able to also be asserted under 1983. That's the C. Clamors case. Another one has to do with a special ed and it came out of Rhode Island, that where there's a comprehensive statutory scheme, you have to go through the statute. But we've also, and this was one where we're on the same side, we've also said, but there are some exceptions to that too, where there's no administrative relief that could possibly be had. So these are additional opportunities, including ways to add value to your claim. And where you have a 1983 claim, there's also the opportunities I mentioned before, in addition to bringing in additional parties who might not otherwise be amenable to suit in federal court in their own name. You may also have parallel claims under other statutes, such as a Title VII violation or the ADA, or Fair Housing Act. And you may also have pendant state claims that you can assert that give rise to comparable conduct. I mean, I'm thinking the First Amendment area where you've got a government agency, the state whistleblower statute is always going to be applicable. And it may give you more avenues of relief than some of the defenses that are available under the jurisprudence under the First Amendment. So you should always be looking at where you can add value by bringing in these additional claims and not just go directly with the 1983 claim, but sometimes the 1983 claim is your basic claim. And if you are successful, as we'll talk about later, you can recover attorney's fees. And that can be a powerful incentive if your state law claim does not have that component. Do you have anything else you want to talk about on that one? Then okay, then I guess we're going to try to go to the next slide. Okay. Wait. Did I miss one? Yeah. How did we? Okay. So I don't see this slide. I don't know where it went unless it's out of order. Any citizen of the United States or other person within the jurisdiction thereof. Am I not seeing it?
No, it might have been skipped in the deck, but you can.
Okay, all right. So this is who can sue. And these days, it's important to know that you do not have to be a citizen of the United States and you can actually be undocumented. You have to be subject to the jurisdiction. You can't sue from a foreign country under 1983. Unless you happen to be a citizen and you're saying something like, I can't come back because they've got some special rules that in the state that are impacting me. But you do not have to be a citizen of the United States. You don't even have to be a natural person. You can be a corporate entity. There's plenty of case law that allows an association representing the interests of its members, typically in injunctive or declaratory cases. There's another form of organizational standing that allows an organization to say that that this particular challenged law or activity is diverting my ability to do my core mission, and therefore I'm being injured, the entity is being injured by it. But they're all persons within potentially within the meaning of being a plaintiff under 1983. And this also includes persons in prison. And as I said, undocumented persons within the US.
I think the big takeaway here is you can be undocumented. In years past, you wouldn't see that. Now you can be undocumented and bring a suit. That's fine.
I think there's a question.
So say if someone is deported while the case is pending, what happens then?
I don't think that moots out the case, unless it's for injunctive relief. If they're looking for some kind of damages, then the action took place. They don't have to have been in the country. I think they can be out of the country when they bring the suit, as long as what they're complaining about is something that happened
But
when
let
they were within the jurisdiction.
me put on the defense practical hat. How are you going to prove your case? That's the other thing, you know, but.
And if you're one of a number of named plaintiffs, or there's an organizational plaintiff, it may survive even given the unavailability of one of the named plaintiffs.
Okay, so now we've got the next slide, which is shall be liable to the party injured. Something is the matter with these slides. They did not come out the way I.
Are you out of order?
No, it's just cut off.
Oh, okay.
The half of the information, it's shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. So trust me, that's all on there. I know what I'm going back to. That one.
Okay.
Okay, because it should all be there now. Yes. So this is basically focusing on what relief is available and what types of relief one can get under 1983, and compensatory damages, nominal damages, punitive damages except against government entities. Punitive damages can be against individuals sued in their individual capacity, and state laws capping damages against municipalities do not apply because once again, you're in federal court. Well, you can be in state court too, because the state court has to apply and provide a forum for 1983 claims. You can bring it in state court. It's not subject to any state limitations such as caps on damages if it's not a cap under 1983. And I don't remember there being one. So it would not apply because of the supremacy clause. The state has to enforce the federal laws. They can't set up barriers, and the federal courts also. For example, if you have a Title VII claim, which has limits on size of recovery of compensatory damages, those caps would not apply. Expert witness fees are not generally available for recovery under when the claim is under 1983, though. The source for costs and fees is section 1988. I don't have that up here, but it provides in certain types of cases that you can recover expert witness fees, which in some of these cases can be substantial. If you have a medical expert, if you have other kinds of experts, that's very important. Attorney's fees and costs are recoverable in all 1983 cases. There is a standard that says that they favor the prevailing party when they're a plaintiff, and it's a much harder standard for a prevailing defendant to recover. Basically, they can't unless you brought a frivolous case or continued to litigate it after it became clear that it was frivolous. And the important thing there from the standpoint of those of us who actually want to see the fees is that even though you can't name the state and get damages out of the state treasury, there is Supreme Court jurisprudence which says that you can get the attorney's fees out of the state treasury if you have otherwise held them liable, such as for prospective relief. And I'm gonna, do you want to talk about the demand for fee waiver? I mean, that's a nice defense ploy. I don't think you do that often.
I know, I don't even know what that is.
Okay, so there's a case called Jeffty versus Evans. And it doesn't, it probably doesn't have much impact if you're doing a serious case for damages, as opposed to asking for some kind of non-monetary relief where if a government agency says, we'll give you everything you asked for in the form of a judgment, which they never like to do. So that's your usual safety net. But we'll give you everything that you asked for, but you have to waive fees. And this could be on the eve of trial or after 3 rounds of appeals. It doesn't matter if your client says, I want to do that. You have to do that. It's not unethical for the state to demand that. And then you need to look at your retainer to see whether they can afford to pay you. This is usually a problem for public interest nonprofits, legal services, where you have an independent obligation to represent the individual and they're indigent. They're not going to be able to cover your fees. The saving grace, and this is just like a practice point, is that in my experience, the state agency or the municipal agency never wants to enter a judgment, which is the only way they can demand this, that says you are entitled to all this relief. And we want to condition it on a waiver of fees. There is the other alternative that they amended their statute or withdrawn their policy in an official way that moots out your case. And that may preclude you from recovery if you haven't already established in some legally binding way that you're entitled to the relief. So there are cutouts, but it's not as dire as Jeffty in most cases because they really don't want to do that.
Maybe let me talk about Rule 68
Yes.
now. Well, I don't, Jeffty, I don't do, but the trend for us on the defense side now is to use Rule 68 offers of judgment. And what we do is if we look at a case and we say, there's some merit to this, but I'm just going to throw out a number, but it's 50,000. We don't think the plaintiff's going to get more than 50,000. It's going to cost 300,000 to try the case. Then you use Rule 68, you do an offer of judgment, you throw it in, and now you've got something to go at. You say to the plaintiff's attorney, you got to reach that, you got to go higher than 50. We don't think you are. And if you don't get your attorney's fees. And so there's a lot of, you ought to look at that rule. It's called the Rule 68 offer of judgment. The issues that we have are, do you include the attorney's fees in? So if I prevail and I say, well, the jury only gave me 10,000, but with my attorney's fees, it goes beyond the 50 that you mentioned. I don't think so. But our Rule 68 offers of judgment say, we will give you $50,000 right now and reasonable attorney's fees up until this point. Then they've got 10 days to say we take it or we don't. If they don't, it's off the table. Court doesn't know anything about it until you go to trial. Jury comes back at 49,000. You're out your attorney's fees. So watch for that. That's something that you got to look at and say, what reasonably, what do I think a jury's going to come in at? So gone are the days when, you try a case and we know we're probably going to lose, but plaintiff wants 100,000. We think the jury's going to come in at 15, and we're right, but the attorney's fees eclipse that. Those days are gone under Rule 68. We use that quite a bit. So be thinking about that. One other thing is, you can bring a 1983 action in the state court. If it comes to my office, you're going to be in the federal court because we remove all of those. And we remove them not, I always say a federal claim should be tried in the federal court. But I love the state court, and I love the federal court. I love everybody. But if you're in the state court, you're trying that case 8 years from when it gets filed. And the interest will kill you. And so if you try it in the federal court, you could try it within a year and a half, 2 years, 3 years. Insurance companies like it to be in the federal court. That's what we want to be. Win or lose, we want to close our books in 3 years, not 8, because they have to reserve, amounts per year. They don't want to do that. So every case we get that has a 1983 component in it in the state court, it's going over. Anyway.
Yeah, just a couple of points on the Rule 68. So in the version that Mark gave you, you would get your attorney's fees up to the date of the offer, but not afterwards. And it is possible. I don't know whether it's a good or bad strategy, but a defense firm could file successive Rule 68s and just keep going higher and higher if they thought that that would help.
We don't have time, but yeah. Usually if you try, this is the interesting thing. You got to talk to the claims rep and the client and say, what is it that we think this case is worth and no farther? And by the way, you're subjecting yourself to a judgment. So the insurance company doesn't care. It's just money. But the client is like, whoa. If they accept that, it's a judgment against me. Yes. Yeah, it is. And so it's a weight thing for both sides to think about.
Yeah. And so in addition to the monetary relief in the proper proceeding, there's the availability of declaratory relief and injunctive relief. Now, in order to get injunctive relief, you need to establish that you're entitled to prospective relief. You have to show either that you have a credible threat that the particular challenge action is going to be enforced against you, or that it has been and whatever the issue is, it's ongoing, or will recur. Otherwise, because they look at standing on each claim, and if you're, for example, with the situation, the person who's no longer in the country is never going to have this happen to them again, they might get retrospective relief, but they're not going to get prospective relief. Okay, so now we're going down to the part where it says somewhere in there, except about 4 lines down, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. This is a recent addition to the 1983, designed to do an extra carve out so that judges don't get named pretty much for anything. Because they already had and do have absolute immunity from damages. So this one basically says that unless you already got a declaratory decree against a judicial officer and they ignored it, you cannot get injunctive relief against, basically you can't name the judge. We had one, I don't remember how long ago it was, but where I can't remember if we named the Supreme Court, but we named the clerk. And we definitely left the Supreme Court out, or we dropped them because of this language. But it was enough to have the clerk. We needed someone who had the authority to enforce a particular rule that we were challenging as unconstitutional. But in addition to this language, which is the one exception that's specifically in here, there's a number of others. Some of them are statutory, and others are recognized in the jurisprudence. And I'm gonna let me go through my laundry list, and then you can talk about qualified immunity. So there's the Tax Injunction Act. If anybody of you followed the truck tolling case in Rhode Island, originally it was dismissed in this court as a violation of the Tax Injunction Act, which says that you cannot, you can't bring, the federal court can't enjoin the collection of state taxes. The First Circuit said this wasn't a tax and reversed it, and but that's by statute. The PRLA, which stands for something like Prisoners' Rights
Prison Litigation Reform Act.
Yeah, that's the one. The reform is the typical reform language that we on the left don't view as reform, but we view with alarm. It requires the individual prisoner file a grievance first, and there's substantial limitations on scope and types of recovery. There's judicial decisions that pretty much the entirety of domestic relations, divorce, custody is off limits to the federal court. It's not just 1983, it's any claim. If there's a pending state criminal or quasi-criminal proceeding, case of Younger versus Harrison, ones that have followed it, say that you cannot go into federal court to challenge or interfere with that pending criminal or quasi-criminal proceeding. Prosecutors, in addition to judges, legislators, and other people who are acting in a legislative capacity have absolute immunity from damages. And then there's qualified immunity from damages. And Mark, take it away.
Well, here's the thing. I mean, everyone talks about, we could spend 5 hours on qualified immunity. And everyone gets nervous about, well, I shouldn't bring this suit because you're going to move for qualified immunity in and off. I'm just going to use police officers. Police officers have qualified immunity. So I see enough of everybody out here who has brought cases, civil rights cases, or defended them. when's the last time anyone has had a case that's been thrown out on qualified immunity? Seriously? Vicky, when? One of mine?
Coventry,
Lopero.
yes.
Okay, I'm glad you brought that up. Because that was the soccer case where they were, Vicky, just 2 minutes, go ahead, go through them.
The Central Falls boys soccer team went to an away game in Coventry. They were accused of stealing iPods and other things out of the Coventry boys locker room. They were already boarded the bus to leave. They were marched off the bus, searched in front of a crowd, had their items held up. You know, if they had an iPod or something, like Casa pulled it up, they belonged to anybody. They had a lot of racial epithets flung at them, told to go back where they came from, so on and so forth.
Yeah. So, Judge Smith threw that out on qualified immunity. First Circuit upheld, right? We argued that in law school. Yeah, that was a good one. That's 2011.
Mhm.
I can't think of another one since that I've gotten out on. We always use it, but I can't think of another one since 2011. You happen to be the last one, sorry.
Yeah, I've said.
Yeah, I've tried, yeah, but see, I don't, so here's the thing with qualified immunity, you know the elements, and I don't have to go through it, but is it a clearly established right, and is it reasonable for the officer to know that he or she is violating the clearly established right? Okay. The judges in this jurisdiction, I'm not saying they're wrong, and I don't know what other jurisdictions do. The law is, if there's a factual issue surrounding those two elements, you don't have a direct right of appeal. And so I think by and large, these qualified immunity issues, courts say that's factual. We have to go have a trial on that. And then I'll decide it. And so then we have the trial, and Ryan is there, and Kathleen, they know. We have the trial, and we say, all right, Judge, now, on a Rule 50, qualified immunity, yeah, forget it. We've gone through everything. We're just going to hear what the jury says. And then if the jury comes in against you, that qualified immunity goes out the window. So I'm not so sure that if you are on the plaintiff's side, you should get nervous about qualified immunity. Like, I wouldn't not bring a suit because I say, I'm going to get hit on qualified immunity. It's not, I don't see that as much as we did, as much as we used to rely on it. So anyone have any different feeling? John Verdecchia, what do you think?
You're the master. Well, it's good to say.
Keep talking, John. This is great.
Eventually, I may get to the promised land. So far, I haven't.
Yeah. So I don't. The point of it is, when you get a pro se case, or if you take on a pro bono case, I don't think you say to that person, you know what, we're going to lose on qualified immunity. I don't think that enters. You may lose on that, and we certainly bring it. We have the law, but I wouldn't,
So
worry about it.
I have a couple of points on qualified immunity. One is that I agree with Mark. I would not decline to bring a case on qualified immunity. But you need to be very aware of the facts and whether you can, move forward on the clearly established federal law. The law seems to be shifting a lot on what's clearly established and what will be satisfied. But from the defense standpoint, you better be really certain of your facts. You can file it as a motion to dismiss. You can file it as a motion for summary judgment. You can take an interlocutory appeal. And God forbid you're wrong, because you should see the attorney's fees bill on the other side when you're trying to negotiate a settlement or respond to a fee application if you lose because you just magnify the cost of litigating. That can be a deterrent for plaintiff's attorneys at times, but I mean, it cuts both ways, because it's so fact driven. The other thing I would point out, and anybody who wants access to it, let me know. We've taken the position that we're pretty much whenever a qualified immunity issue comes up, in a very perfunctory way, we are briefing that this is bad law. You know, acknowledging that the lower courts can't do anything about it, but it should be abrogated by the Supreme Court who made it up. That it is, I mean, there's so much law reviews, legal argument. The legal argument is now coming from both the right and the left. It hasn't worked so far, but we've briefed it in a number of cases, that it is incorrect. There actually was language when 1983 was passed that indicates that it wasn't, that the council's against reliance on it, and that it is should not stand, just to basically assert it, preserve it, because your case might be pending, and you know, hope springs eternal that someday, as I said, right on the left on, you know, are not liking it, that it will be abrogated, and you want to have preserved your defense that qualified immunity is not a cognizable basis to defeat recovery.
So I just want you to all know that all of you plaintiffs attorneys out there, next time you bring a case, I'm gonna say, hey, we got qualified immunity. Like, you gotta go down on your demand. So that's coming, but you know, it really doesn't matter.
So I want to thank everyone. I'm fond of saying, and I stand by this assertion, that Lynette and Mark have forgotten more about 1983 litigation than the rest of us are ever going to know. So having this opportunity to really dig into the questions of, if you're thinking about jumping into an appointment in a pro se case, if you're defending a case, if you're thinking, you're sitting in your office with someone who's brought a set of wrongs to you and you're thinking about framing your case, you now have more of a framework to think about. What are you trying to accomplish? Are you seeking damages, injunctive relief, declaratory relief? What happened? And who are you going to sue? And who is going to be suing? These are the things that often get people tripped up when they're first framing litigation under 1983. And we got a lot to think about today. You didn't get a simple cookbook response on the answers to those questions, but now you know what the right questions are to be asking yourself, whether you're plaintiff's counsel or defense counsel. And so that's why you have to come back in 2 weeks, because we're going to drill down into the next layers of those questions.
I would add, even though it's entirely against my self-interest and that of the court, that we didn't bring you here just to convince you to join the pro bono panel. I mean, we hope that some of you will become interested enough in 1983 litigation and the prospect of doing more federal court work, that it will be to your benefit to take pro bono cases or a pro bono case. But we want you to be more aware of the field and the litigation that's going on and the opportunities here. Et cetera. Court is a great place to try a case. And as Mark said, you don't wait until you're as old as I am to finally get on the trial calendar. So don't, you know, we talked a little bit here and there about the pro bono panel. We talked about that more in the last session, but you're signing up for this. Didn't sign you up for anything that you didn't intend to be signed up for.
And I think there's a question.
Do you know statistically what percentage of civil rights cases get dismissed by the federal court
Yes.
At
Summary judgment stage.
Okay, so I've got these statistics. Here we go. I'm gonna go through them because it'll answer I hope it answers your question, but I'm using the calendar year 2024. 120 civil actions were filed by pro se plaintiffs. That's 22% of the total civil caseload. And that matches more or less the last 5 years. So it's about 22%. Of those 120 civil actions filed by pro se plaintiffs, 35 were prisoner civil rights actions. Of the non-prisoner pro se cases, 45 were filed under 1983. So 80 of the 120 pro se cases were 1983 actions of some type. And for the entire civil caseload, pro se and counsel cases, about 36% of the caseload are 1983 actions. I think here's your thing. Of the 120 pro se cases filed this year, 75 of them were closed in this calendar year. The overwhelming majority were dismissed on a 1915 review. That's in-house.
It's a screening review.
Or lack of federal court jurisdiction. And a smaller group via motion to dismiss. So you've got 75 of the 120 out. Another 45 went through that process. Of these, 13 have motions to dismiss pending. Another 4 have been answered, and the remaining are waiting for amended complaints to be filed to cure a defect. So really not that many.
That's really about the court's total caseload, not the pro se caseload, right?
My perception is that civil rights plaintiffs represented by competent counsel are having their discrimination cases dismissed at the rate of 75% in federal court in summary judgment stage.
In the US? Because not
In the
here.
US.
Okay, not here. I'm just telling you, like.
Well, I'm
Yeah,
curious.
I don't
about
know
this
the
statistic,
answer.
Because that is one of the reasons why you don't have more attorneys taking on civil rights cases, because the courts, there's a perception that, oh, the court's docket is so, all they care about is making sure their docket is moving, and so they dismiss a lot of civil rights cases for to present a material issue of fact, and as a matter of law, the plaintiff can't win.
Okay, so let me dispel that in this court, because I've had arguments, not arguments, but nice discussions with the judges here. I don't even file summary judgment motions unless I have to anymore, because they don't get granted.
How many cities and towns do you represent?
All but like 4. Honestly, I try not to. The process is long. You get your complaint amended. You're telling them what your theory is. They never get granted, and as Lynette says, the fees go up and the case is lengthened. So I try not to file motions for summary judgment, and I don't. I'm looking at you, Bob. I can't think of one that's been right.
So I
maybe in other jurisdictions, not here.
definitely, and here's the good news. In 2 weeks, we're going to tell you the answer to your question, because that is available through research in the court's records. But I think that the perceptions of both plaintiffs and defense counsel are that the situation in this court would probably be a bit different from the national statistics. In terms of both Lynette and I have recent experience, certainly with cases that were able to move through the process.
Yeah, but I think your question is, to some extent, was focused on employment discrimination, which is a form of a civil rights case, but they're not usually 1983 cases. They might be against a private employer. Sometimes they're against a public employer. I think you're probably not wrong. I don't know about the percentage, but a lot more of them are met with summary judgment. And I have, I think the bench here is a good one, but the national bench on employment discrimination summary judgment is, it's can be fairly onerous in terms of surviving the summary judgment, which, you know, causes a lot of people to file in state court.
So
As their go-to place. And sometimes even strip out the federal claims so that they can't be removed by Mark to federal court.
So now we have a cliffhanger for 2 weeks from now, because we'll present some statistical evidence at that point. And we're at time, we want to respect people's time, because this is a long series and we want you to keep coming back. So thank you for being here.
Yeah. Didn't get all of the. Yeah. Because like. This is the box here, one's the header and one's the box. It cut this part off.